states that the board has stated in different cases filed in the High Court that so-and-so candidates were selected, but no merit list of so-and-so candidates were ever published by the board. The board should be directed to publish a merit list by disclosing the numbers obtained in written interview, reservation category-wise should be published. Candidates were informed through SMS and no merit list of candidates were published, and it proves the mischief in the recruitment process. If the process was free from corruption, then there ought to have been a transparent merit list of the 2014 qualified candidates. The process was not completed in. We are completely oblivious of, my lord, the scope of the writ petition. Where I have placed the writ petition in my opening submissions, I will not place it once again, but please note down the paragraphs and the points once more.
Yes.
Well, what are the 5 or 6 facets of the writ petition?
Like your contention of the applicants in various scans, they have dragged the scope,
including the writ petitioner.
Yes, we have taken. They have gone beyond their pleadings and prayers in the
Yes. Now, the scope of the writ petition are, my lord, according to me, 4 or 5-fold, my lord, scope. First is scam in TET 2014. This is very, very important. Scam in TET 2014 is the allegation. Your lordships would find this in paragraphs 12, 16, 17, and 18. Just note down here. I'll not waste your lordship's time in placing those.
16, 17, and
18. So the fundamental challenge is so-called scam in TET 2014, which according to them vitiates the TET 2014. The second is, which again is contrary to the first one, is that all TET 2014 candidates are entitled to the benefits of relaxation by MHRD. I don't know how these two can go together, be that as it may. The second is that all TET 2014 pass candidates should get the benefit of relaxation of qualification granted by or allowed by the MHRD.
the submission was otherwise.
Yes.
Said that on the date of the advertisement on 26 September, the extension period was already over prior to September.
That's what
he says.
Yes.
That the persons who participated, correct us if we are wrong, persons who participated as TET qualified teachers, in respect of them, those who came within from March to September, this period was a gap. So they could not have availed the relaxation. So something that was
Yes.
But
Election periods elapsed on the month of April, and thereafter the advertisement on the month of September. So in the interregnum period, there is no such relaxation.
That is what he
Yes,
said.
yes.
That was it. So
I have an answer to that also.
What is, they have not argued that all TET has to
No. That is the subject matter of the writ petition. My submission is that whether, my lord, they can stretch it beyond the pleadings or the subject matter of the writ petition.
Second point was,
Yes.
state what you are saying.
The second point is laid out in the writ petition, in the pleadings.
Yes.
The second point is, which according to me is contrary to the first point, is that all TET 2014 candidates should be given the benefits of relaxation. Yes, that is what I intend to point out. That what is the case and what is the argument?
This contention, in which paragraph do you find?
These are available from paragraphs 7, 8, 9, 11, 12, 20, and 21.
Please explain what did they say. All TETs are not. They are not saying that.
Yes, can you have a look, Miller?
Which paragraph tell us?
Milord, 7 onward, kindly have a look, Milord.
That section, your submission, all take candidates.
Yes, yes. Please,
Then the benefit
yes.
of that session.
Please take, Milord, paragraph number 7, for instance.
Yes.
It starts at page 29 at the bottom.
Yes.
Your petitioner state that on 11/10/2015, TET 2014 examination held in West Bengal, where huge number of students appeared. It is needless to say, this sentence, it is needless to say that on the date of examination, the notification issued by the MHRD Government of India was in force, and all students who have passed or qualified in the TET 2014 should get the benefit of notification of 9/4/2015. This is the pleading. I'm showing only one paragraph. The rest of the paragraphs, Milord, which I have highlighted.
So this pleading is contrary to
The submissions are completely dehorsed.
pleading is contrary to the submission. That,
Of Mr.
that
Yes.
gap period is not their case at all in the
Right. I have an answer to the submission also.
Yes.
that I'll make.
Yes. Now, if this is, what is your answer to this? This is right or this is wrong? That they should get the benefit?
Yeah, no, there is no dispute on that. They have got the benefit. That also I'll demonstrate. But I've got twofold answer to that. The easier way to answer is that they have got the benefit.
They have
Got the benefit. But, Milord, the other way also, Milord, the qualification, the gap that they are saying, the gap was also, Milord, filled up by the circulars of MHRD, which has not been brought to your Lordship's
no,
notice.
Mr. Lady or Mr.
Yes. No, no.
Hussain or Mr.
Mr. Bhattacharya is placed at 2017. Yes, yes.
Yes, where is that in your compilation that blueprinted? You know the page of that?
101. He's in his compilation, page number 101.
আমি একটা দিয়ে দেবো
দে
এবার দুটো নেই
Yes.
101 is 17 amendment.
Or we shall got it.
Yes.
Your argument. All right, Mr. Bhagavad, if we forget, we will take. Yes. Yes, Mr. Bhagavad.
There's an additional submission to that also. Assuming there was a gap.
So we will go to that first. So their argument, their
Yes.
contention was that all TET should get, that
Right.
all TET did not get the benefit.
Right.
This is other statement of theirs.
Right.
But you said that all of them got the benefit.
And that is recorded also. I'll place all those.
Yes.
But this is where the second facet of the writ petition. But the third facet is, which is very important, in respect of, Milord, the relief that is granted, is that what was the writ petitioners praying or claiming?
That relief they did not take.
No. The writ petitioners were claiming parity with those who have got appointment.
Yes. Yes.
And alternatively, they say, I must be fair to the court also, alternatively, they say that if I cannot get appointment, the appointments which have been given is bad.
So their case was that there are vacancies, we have been discriminated.
Right.
To give us a
Right,
This was there.
right.
So that is strengthened by the fact, according to you, that you see the prayer, there is no prayer for settlement.
Right. This your Lordship would find word in paragraph 11 of the writ petition. But then there is a, Milord, an omnibus submission or, Milord, contention raised that since 2011 there has been corruption in all selection process.
That you have argued
Yes.
corruption, etc.
Yes. This, my lords, will find, my lord, in paragraphs 14 and 22.
14 and 22.
22. And, my lord, the last point is that, my lord, no merit list was published and there should be a direction to publish the merit list with reservation and all that. Now, this merit list is for what? This is again very important. Merit list, not of the recruitment. Merit list of TET 2014.
Where
Yes. Please take, no, kindly see the pleadings first. Then, my lord, we can go to the prayers. Please take me paragraph 18 at page 34 of the writ petition. Your petitioner states that the board has stated in different cases filed in the High Court that so-and-so candidates were selected, but no merit list of so-and-so candidates were ever published by the board. The board should be directed to publish a merit list by disclosing the numbers obtained in written interview, reservation category wise should be published. Candidates were informed through SMS and no merit list of candidates were published, and it proves the mischief in the recruitment process. If the process was free from corruption, then there ought to have been a transparent merit list of the 2014 qualified candidates. The process was not completed in so-and-so, and the department is well aware of the same, and this honorable court should take notice of the same. Persons who did not qualify for TET 14 were appointed as primary teachers by the board in spite of the specific case steps not taken, and
yes.
And in spite of specific case, steps were not taken, and it shows that there was corruption and illegal financial transaction while conducting the recruitment process. The department ought to have taken suo motu steps, but that was not done for the reasons best known to them. Moreover, many candidates complained that TET 2014 qualified candidates were not issued to, certificates were not issued to them. And even today, they are fighting for that. There is no delay in filing. The public interest.
But what is your answer to their repeated assertion that no panel was published?
Yes.
The answer to
Yes, yes. But on that, will
these 5 points you have.
yes, yes.
You please answer to their
Their contentions one by one. Before I go to that, please have a look to the prayers once more. My lords have gone through it.
prayer. There is no prayer for cancellation of the recruitment process of 2016.
But the matter ends over there with respect. The standard charter does not apply. My learned friend Mr. Bhattacharya has found out standard charter. Standard chartered was a case which went before a special tribunal in a suit constituted under a special law. Yes, that judgment is on a point that if one issue is before the court, not before any forum, a connected issue can be argued or can be decided. But so far as writ jurisdiction is concerned, there are umpteen number.
The answer when you
Yes.
Now you please.
Yes.
How do you answer these queries?
Yes. Now, first, my lord, I take the point of relaxation. Where the rule is not under challenge. I mean the recruitment rules. Please have a look to, my lord, Rule 6, Sub-Rule 3 of the 2016 rules.
That 2 years time for completion of training.
Now, this completion of training has happened within 2 years. No dispute. Now, my lord, in my very respectful submission, if Rule 6.3 has been complied with, the issue of relaxation or the gap, as they are trying to point out, does not remain, my lord, an arguable issue or an issue to be decided in this proceeding.
No, if this rule 60 has been complied with, then also the persons cannot say that you have not conducted the inspection as per the procedure.
No, no, no. My lord, please come back to Rule 60 once, my lord.
That is the argument which Mr. Pradeep
Yes,
said.